Friends, we are going to start now. Today is the 275th Friday group meeting. The topic is important cases argued by our beloved speaker, Dr. Abhishek Manu Singhvi ji. And a gracious last 11th hour I catched him. I tried my level best to others so many, but all are preoccupied. Sir, immediately, 11th hour, even though he cancelled his matters now in the NCLT and Supreme Court and High Court, he came here. Give a huge claps to him. Sir, you have such a glamour after circulation of this thing. So how many people have praised you? I never expected, sir, honestly. It's more than this thing. Now we'll go first. We felicitate sir. It's the 275th Friday group meeting. So that this is and celebrations also. So that we'll start with that. And sir, the one or few things, we have as on date 37,000 subscribers. We have our own YouTube channel, Friday Group, and 227 videos are available, sir. And second, 19 lakhs views we already have in our YouTube channel. And we have our own Friday Group website also. That's one. And two more things. Sir addressed our Friday Group on 15th September 2017. The topic was Institutional Pillars of Indian Democracy. That is lecture number 68. Second time, sir addressed on 3rd February 2023. The topic was Federalism, Multiple Facets. That is lecture number 178. After that, 13th September 2024, our members are designated as senior advocates as a party principal. Any constitutional post or any senior designation, our own members, we are not going for entire SCBA. If at all our members, we are felicitating the part of that. I requested sir that time. Sir has felicitated all of them. And continuously we also felicitation because he was also elected again for Rajya Sabha. We also felicitated him. So this is our little bit background, sir. Now we'll go for felicitation. Huge claps, please. Thank you very much, sir. Now I request Madhu Yadav will say a few words, our CA of our today's speaker, Dr. Abhishek Manu Singhvi, Member of Parliament, fourth term. Please, Madhu, please continue.
Good evening, everyone. So, thank you, sir, for giving me this opportunity and welcome, sir. As we all know, sir is a very renowned person, so there's no need to give an introduction, but yet I'll do the favor. So, sir has been elected, sir has been the fourth term member of the Parliament. He has been the eminent jurist, also former chairperson on Commerce, Law and Home. Apart from this, sir is a member of Congress Working Committee. Also, sir is former Additional Solicitor General of India, Senior National Spokesperson of Congress, Chairperson of Congress Department on Law, Human Rights and Right to Information. So this is a short introduction of sir, and thank you, sir.
Thank you, Madhu. We are giving all youngsters like this one by one. Vote of thanks or any, next thing, CV reading.
You can just keep it here, right?
Should we start? Speak there.
Yes, sir.
Speak there. G.Seshagiri Rao, the midwife, Sutradhar, inventor, birth giver, father, mother and protector of this institution. He's really done a remarkably sustained, continuous job, and I think we take it for granted when we come here on Fridays. It is not easy to keep the flame flying. So I think the special thanks must go to him that he's able to connect you with such regularity. It's not a small thing in these troubled times, and I think there is a larger bond, a larger connection which connects you all, which is to be cherished, nurtured, and promoted. Distinguished members of the bar, I'm embarrassed by the presence of such senior persons like my friend here. He was there at my last lecture also. And a lot of you senior, middle and junior people are all brethren of the bar. Sheshagiri Rao is also a dangerous person to meet in the corridor. So I fell foul of him in the corridor exactly 72 hours ago when I was rushing from Court X2I. And he suddenly mentioned this Friday group. I didn't even know my list, but he's so sweet about it and so dedicated that I didn't have the heart to say no. I wish I had said no. I'll tell you why. So I said, we'll try our best, I'll be there, etc., etc. We had no topic, no nothing. He just said, but I said that day I may have difficulty, so keep it earliest 4 o'clock. Since the time was short, I asked him, I've spoken here earlier, what are the topics I've spoken on. So then when he gave me A and B and C, then I said today I'll speak on a book written and published at the instance of the publisher on the 8 cases I had argued, published quite a while ago now. But in the morning I telephoned him an alarm, a great alarm, because apart from my Supreme Court cases which had a couple of 55s, 160, which would have been manageable, there were a couple of NCLT matters, and I rarely go to the NCLT physically. But A, they were in the afternoon, so they would reach late. So even with VC there would be a clash. And B, one of them involved contempt by one lawyer against 19 lawyers. Contempt petition. That happily got over in the morning. So I telephoned him, I said, look, I mean, if I can't come, I can't help it. I want to come, I made my commitment to you, but this is beyond my control. So we said, we'll see how it works out. As it happened, even the second NCLT matter finished by 3 o'clock. So I called him immediately and I said, I'm coming before time. And we started therefore a little before time because I'd like to leave around 4:30. Friends, there is a publisher called Juggernaut, which many years ago, must be now 6-7 years ago, I don't remember, run by a very capable young woman called Chiki Sarkar. She came to me and said, look, you do so many important cases, you spent a lifetime in law, I'm going to score a half century after 7-8 years from today in law profession. So she said, we want you to write a book dictated to somebody about the 8 most important cases you've done. So my first reaction was, it is like asking a parent to choose 1 out of 2 or 3 children. Because, I mean, as I said, spent 43 years in the profession now. And I have forgotten the number of cases I've done. I've forgotten the names of many cases. I've forgotten the issues. I've spent a lifetime every day, 5 days a week I come here. So I said, out of that to choose only 8. She said, we don't have time for the more than 8 in a book. And then she said something interesting. She said, I want it to be a book which is read by non-lawyers, but is equally interesting to lawyers. Now that's a difficult thing to do. It should be simple, lucid, and not technical, not jargon oriented, not mysterious, but equally of interest to the story behind the story of the case. So the case is this, the story is this, the story behind that story. That will be of interest to lawyers also. So I said, you need to give me a smart young lawyer for that, to help me out. So she deputed Satyajit Sarna, a very, very nice, dedicated, academic-oriented Sikh gentleman, whose father recently retired as US ambassador, Indian ambassador to USA. So I then told my juniors to take out some 20-30 cases which they thought were important. Not I thought, but they thought. Then out of that we kept cutting. So we came down to 15, then 10, and finally we chose 8 ad hoc. And the ad hoc we chose deliberately from different topics. So if there are 8, then some on constitutional law, some on something else, some on liberty issues, some on commercial matters, like that. So that's how this book was born. So today, in the half an hour odd which I will trouble you, let me go through some of the stories behind the stories. This is already a dated book. It must be about 7-8 years old. So I've done many more after of interest, but I'm not going to touch on them because we don't have the time. But in that book, which by coincidence somebody came just now and got me to autograph this one, yes. This is I think the second edition. The earlier one had a very intimidating face of mine on the top of the books, then she changed it to this one. So some other person came and got it signed just now. Prabhat, very good. So the first, let me just give you a summary of the 8 books, 8 cases. There is another version of the top cover. This is not the only version. There is another version of the top cover. Yes. So the first in this is a case called commercial free speech. It's more correctly known as Tata Free Press. Now, you are lawyers, so it's of some interest to you. Till this judgment, free speech is part of our constitution, 19(1)(a), etc., etc. But by a quaint, inexplicable exception, commercial free speech was not held to be part of 19(1)(a). Commercial free speech means free speech used in the course of earning money or doing commerce. Free speech simply said is a constitutional right. 19(1)(a) is a very cherished right. But there is no commercial free speech protection under 19(1)(a). Many of you may not know this. So this is a landmark judgment which I succeeded in, which for the first time in 93 or 94 I think it was, established that commercial free speech is also got the same protection under 19(1)(a). Now how did it arise? There used to be in the good old days yellow pages. You all forgotten yellow pages now because we have mobiles, we have iPads, we have search engines. You don't need yellow pages to search anything. You have all these delivery boys, all these apps. Every app you can get anything, Zomato and all that. Those days in good old days we had only yellow pages. So Tatas used to publish yellow pages. One day they got a notice from, and yellow pages was quite money earning because you would advertise there. I would put if I'm a grocer or if I'm a seller of some clothes, I would put and advertise there and I'd pay money. So one day Tatas got a notice saying that look, under the MTNL rules, you cannot do advertising like this and you have to do this restriction, that restriction, etc. Some kind of various things, some size, some this. You can't do more than 2 ads. All the kinds of show cause notice came from MTNL. MTNL had been born by then. So thank God they decided to challenge it. It needs eccentrics to advance the law. If they are not challenged, the law would not be advanced. So they decided to challenge it. They filed a writ saying it does not comply with rule 494 or 454, I don't remember, of the MTNL rules. That was a straight challenge on interpretation. This rule allows this prohibition, you have done a prohibition beyond this rule. It was argued by a very capable lawyer, a good friend of mine, S.P. Chinoy in Mumbai. And ultimately the court held it is within the powers of 494 or 454 or whatever that rule was, MTNL rules, and dismissed the petition. One day in another case, SP was here, in the corridor he met me, he said, look, Abhishek, it's a very important issue. I am a little, disturbed about this judgment. So I am going to file an SLP which I will argue, saying that this rule does not cover your power. But I want a separate writ, direct 32 writ to be filed, challenging the validity of this rule, which we had not challenged in the Bombay High Court. You follow?
Yes.
So, and I want you to lead that writ. And he said, most probably they won't even list the list or hear it saying that you never argued in the lower court. But I want 2 matters. So I took up the writ thinking that they will have to hear the SLP first. And they'll probably dismiss the SLP, then they say, where the writ, Mr. Singhvi, you never raised it in the lower court. Anyway, the matter came before a very feisty judge, our great court number 2, Justice Kuldeep Singh. Kuldeep Singh was always prepared to work outside his comfort zone. He was always looking for innovation, very dynamic, very fast, very aggressive, etc. So opposing me were K.K. Venugopal and Arun Jaitley for MTNL and for other people. And with me was SP Chunoy. SP started the SLP. Suddenly, Kuldeep Singh says, but Dr. Singhvi, what is the other matter? So I said, this is a virus challenge. He said, tell us about the virus challenge. So what was to be a subsidiary case became the main case. I explained to him that your lordships should hear and strike down the rule, because this rule impinges free speech. This 494, forget the interpretation of the rule, it impinges free speech. You strike it down. But your lordship will tell me that we can't strike it down because commercial free speech is not protected under 1918. Then I argued that your lordships have held in Hamdard Dawakhana, an old judgment, constitutional bench, that another old 1933 US judgment, US Supreme Court, I believe it was Christiansen, has held that commercial free speech is not part of the First Amendment. You know, the First Amendment in America is the same as our 1918. So they had held that judgment. Christiansen held that. Your lordships followed in 33, and since then you have been repeating it, Hamdard. But Hamdard should not be followed now, I told the judge, because after Christiansen in the country of its birth, USA, there is a separate later judgment, Valentine, which is overall Christiansen, and has held that commercial free speech is part of is part of First Amendment. So I said, if in the country of its origin, commercial free speech is protected, why the hell are we continuing to say that 1908 doesn't do it? Now Kuldeep Singh, it struck him. Then Venu and Jaitley argued that Hamdard is 5 judges, you are only 2 judges. He forgot about the SLP. He didn't touch the SLP. He said, but let us see, that is 5 judges, but that was based on something which is not before us today. Today there is Valentine. Ultimately they heard me, and in a 2-judge bench they held that commercial free speech is part of 1918. It is a huge judgment which has been followed in innumerable cases later on. So I conclude on my first case. It gives you an idea of the dialectics of how a case is formed. The case was born in Bombay on a different issue. It travelled on a different issue here on SLP. Suddenly came a writ, validity, and luckily a bold judge held that if Hamdard of India was based on Christiansen in US and Christiansen was overruled, then we jolly well follow the new judgment of US and not the old one. That's the commercial free speech done. That's the law till now. Fortunately, nobody has tried to overrule it on the ground that this is 2 judges and Hamdard was 5 judges. But someday that will happen. Somebody will raise it. My second case in the book started with a great privilege and an honor when I was a very young lawyer. I was largely briefless, and I got a Sikh gentleman whose clothes were torn and used to come in slippers sometimes, very, very impoverished, who had been some lowly government servant in Chandigarh administration, and he had been sacked or something, suspended, and then he had been evicted from his house, or at least had got notice of eviction. So he travelled here and there, he lost in the High Court, he landed up at my doorstep because he knew that I had not charged him much. So I took up that case. That case came before a Marxist card-holding judge. Many of you don't know that prior to becoming a judge, Justice Chenappa Reddy from his state used to be a member of the Communist Party. Although he shed all those affiliations, but he had a leftist bent of mind, but he was actually a card-holding member, a very good judge, very strong judge, and very fast. So when the matter came, I argued it. I think he liked the fact that here was a young man devoting so much energy on a non-paying, impecunious Sardar who had nothing in life, who had lost everything. Finally, he dismissed, but gave him some time to vacate, etc. 2, 3, 4 months later, I happened to be sitting in his court when a just retired judge of the Calcutta High Court called D.K. Basu, the judge's name, wrote a letter saying, I just retired, I could not speak when I was a judge of the High Court of Calcutta, and now find that there are all these custodial deaths taking place in West Bengal and many more across India. And please treat my letter as a letter petition PI, That landed up on Chennappa Reddy's desk. Maybe the Chief Justice marked it, he used to sit in court too. He never became Chief Justice. Now he got the letter petition has to be made into a case, then it has to start. So on that day, by quirk of fate, he looked around and said, look, this young man is sitting here, he was nice in that other matter. So he made me a micro curate. This is in 1987, if I remember, or 86, maybe earlier. Teja Singh was 1986, this is 1987. That matter, of course, left Chennappa Reddy after some time, he retired. But I did 3 direct judgments of D.K. Basu over 22 years or 25 years, and many other interlocutory orders. And it was one of my most important amicus briefs. I've done others also, but this was because here we were addressing a very crucial question which has no solution, which even today has no solution. By the way, D.K. Basu is still listed in Justice Sanjay Kumar's court last week. So I am seeking new guidelines about the new BNSS. The question we raised in D.K. Basu was this very crucial question which has no real answer, but we wanted to minimize the abuse. It is this, that all the atrocities which I commit on him are done before I arrest him. So if I have to torture him, if I have to do something to you, if I have to harm you, if I have to hit you, if I have to practice unconstitutional methods, I will first pick you up, take you to a place and do that. And I will show that I arrested you 2 days later. And all the safeguards of the CRPC come in when I arrest you. There is no safeguard before you arrest. So I raised the question that how do you increase the safeguards, because the lack of safeguards, the safeguards start from the point of arrest. How do you minimize it to prevent custodial death and custodial torture? That is what D.K. Basu is. In my first D.K. Basu, which was heard at great length by Justice Anand, and he paid me a rare compliment at the end of the judgment, he devoted a para saying he appreciated my assistance. He laid down the original 10 commandments of D.K. Basu, which are exactly as I gave them in written submission to him. For example, that this police officer will wear a band with a name, he will inform the next of kin or the wife or the brother, he will give a notified number, he will keep informing. Maximum we could think of, we gave. And Justice Anand, after hearing all the states, gave a judgment which was included all the 10 safeguards. Then after many years came D.K. Basu 2, again by Justice Anand, after 5-7 years. Because D.K. Basu is an ongoing thing, it goes on. Where he gave a second set of commandments. If you read the D.K. Basu commandments, they are a significant advance of at least protecting against custodial death and custodial torture. Nothing can eliminate, I can still pick you up and beat you around, but there are safeguards now. Then we had guidelines like all the 10 commandments of D.K. Basu should be displayed on the wall of a police station. All that. Then the third round of D.K. Basu, which finally he closed it, was Tirat Thakur, Chief Justice Tirat Thakur. He heard, he gave further guidelines. So I made 3 commandments of 10-15 each, some 45 commandments as amicus of D.K. Basu. Now we are trying to do, in between some other matter decided CCTV, which was also my list, but that happened in some other judgment. Now we are trying to suggest how 41A, the power of arrest, can be regulated best. 41A is not 41A now, it's the news provision, I forget what number it is, BNSS, but it's the same concept. That has become more safeguards. So we want to sync it with D.K. Basu. That's the second, but that gave me a lot of satisfaction. It also helped me in my early years of practice. I became a senior in 93, but from 87 to 93, D.K. Basu took me to many destinations. And the third case, which I have dealt with in the book, is a very complicated case, a very emotive case, a very difficult case, and it's still pending. And I got the unpopular brief. I believe that sometimes the best comes out in unpopular brief, if you are able to prepare it. This is the Sabarimala case. So Sabarimala case, the brief came to me from the Devasthanam board, which runs. And the whole host of PILs and NGOs and ladies organizations were saying that obviously it is unconstitutional, it is discriminatory, because women from age 10 to 50 cannot go at all per se. Less than 10 can, above 50 can, but nobody. So my written submissions there are reproduced in the SCC. We argued it, we lost 4-1. The woman judge voting for us. Then I won the review before another constitutional bench. This was constitutional bench. We filed a review, we won that, and now it is open in review and pending. So it's not decided. The issue was very complicated and difficult. Why? I had to justify the exclusion of women from a temple. So those written submissions had many constitutional arguments. The heart of the argument was a little complicated, which I'll just take 2 minutes to explain. I said, look, Article 14 does not prevent classification. Article 14 allows me to treat him and him differently. But it requires that there must be a reasonable object, the nexus of which is fulfilled by the differentiation of classification. I cannot make equals unequal and I cannot make unequals equal. But I must show rationality to the distinction. There I said, the case was based on Article 14 because women were excluded, en masse, all women. Second point is that I said that Sabarimala is what? Sabarimala is the only temple in India which worships a deity called Neshtarve Brahmachari. It is a form of God Kartikeya in the form of an eternal Brahmacharya. Neshtik Brahmacharya it's called. That means there are 1499 other temples in India. This is the 1500. All 1499 do not worship Kartikeya, the son of Shiva, in this form, as an eternal Brahmacharya, eternal perpetual. So I said, you have to link the exclusion with the nature of the deity which you are worshipping. Number 3, the nature of the deity being eternal Brahmacharya. There is a validity and reasonableness in the concept that fertile women capable of giving birth to children should not be able to interact with the Brahmacharya. That is the rationale behind it. In fact, even men who actually go to Sabarimala have to practice the pratham, the 40 days of penance, of denial, of self-sacrifice, of going away from their family ties, and then walk, eating, living, everything has to be sanitized. So I said the idea is that women do not gel with the concept of the deity. All the women are welcome to go to all the other 1499 Kartikeya temples in India. But this one celebrates his different form. I then added that there is no absolute exclusion. There is a rationality to the fact that fertile women capable of reproductive abilities are excluded. But less than 10 are not, above 50 are not. Of course, 50 and 10 will be add on. Women can conceive and give birth also at 60. But this is a cut-off they've done. But it has a nexus to the object sought to be achieved. That is how it lay. And then of course we made several other arguments. As I said, Justice Indu Malhotra held in our favour. Then the review, Justice Gogoi's constitution bench allowed the review. It's now pending. But that's a difficult one. It's an interesting issue of law. The fourth is the national flag. The national flag came to me from another eccentric, Naveen Jindal. Naveen Jindal, who has a big industry all over India now, but in those days his main industry was in Mandideep, which is a place near Bhopal. So he had a factory there, and in Mandideep he also had an office and a residence. One day, in his residence in Mandideep, he decided to fly the national flag. So after one day, the district magistrate came and gave him a show cause and said, you better stop this flag. He wrapped it up and took it away. He said, you can't just fly the flag like that. So Naveen Jindal was not a lawyer, engaged Shanti Bhushan, and they filed a petition. He said, look, how is it possible that I can't fly a flag of my own country in my own country? A Pakistani can fly an Indian flag, but the Indian can't fly an Indian flag. An Indian can fly an Indian flag in Dubai, but he can't fly it in India. Well, that started, it came before Justice Vadva. Justice Vadva said this is wrong, but didn't give any effective relief. Matter travelled to Supreme Court, came to Court 6 before Justice Kharel. I used to joke with Justice Kharel later on that this case travelled from 6 to Court 1. It travelled till he became chief. It will be adjourned, etc. Raju Ramchandran was the AS chief. He was opposing me, a very good lawyer and a very reasonable person. So we argued that I made my written submission. Those written submissions are also reproduced in the SCC, journal section. So we raised it on 19(1)(a). The right to fly the flag is a manifestation of all forms of my right to express myself. As a citizen, as a nationalist, as an Indian, as a resident, my expression is this. But I am not claiming a right to fly the flag. I am claiming a right to respectfully fly the flag. See, I can't fly the flag upside down. I can't make a bikini out of the flag. Americans allow it. Americans allow. A lot of people are wearing US flags as bikinis. I can't burn the flag. A form of protest in America is burning the US flag. So I said, we are only seeking a right to respectfully fly the flag. There is no law prohibiting it. There is a flag code. They made a booklet. It's called a flag code. It's a collection of instructions from the government to the DM to the DC and the whatever, Patwari. And they enforce it. Oh, you can't fly the flag after 5 o'clock. You have to fly it only on Independence Day, 15 August. You will only fly it on Republic Day. So flag code is a whole host. I said, this is not law. So under Article 13 of the Indian Constitution, how are you abbreviating my right to 1918? Justice Khare was he got the point, he was concerned, but he was not a very bold judge, he was cautious. So he adjourned the matter over 1.5 years when he travelled from court 6 to 1, trying to put the government, force the government to agree. He said, why don't you agree, why don't you agree? The government would not agree at any time. So I finally told him, I said, you have to pass a judgment. Finally, he has adopted largely my written submission, and the thundering judgment is there, that the right to fly respectfully the Indian flag is a fundamental right under 1918. It can only be curtailed by law. It can only be stopped without law for abuse. If I start dancing on the flag, if I start wearing it to a bar, if I start throwing it down on the floor, if I make it dirty, if I burn it, if I wear a bikini or a swimsuit, etc., etc. But otherwise, we all have a right to fly the flag. Till now, this was, which year I don't remember now, 2004. We are now in 2025. 21 years, Naveen Jindal celebrates 26 January with a Flag Day function. I stopped going now, but he calls me regularly. So this is another interesting case in my life, and these are some important judgments. In 2015, I got a stay. This is not a final judgment, but I got a stay on Santhara. These are emotive religious issues. So just like Sabarimala was, this is another. It doesn't matter that I am a Jain, but Santhara relates to Jainism, but I have been at a council. I am pretty much a non-Jain in practice. I don't follow any of the rigorous schedules of eating before sunset or being very careful about what I eat. But Santhara is an old, age-old practice which we said is part of the, the test from all our old judgments for Hinduism, for Parsis, for Jains, for Islam. The test is, if a practice is an intrinsic part of your religion, essential and intrinsic, then alone it will have the protection of 25. 25, as you know, says profess, practice and propagate. For example, the Anand Margis applied to the police commissioner of West Bengal decades ago. I had a friend here in the bar who was Anand Margi, you know his name, I forget his name now, he used to be here in the bar. So the Anand Margis in Calcutta applied to saying that we have to do the Shiva Tandem dance. And we have to do it on the streets of Calcutta because that's an essential part of Hinduism, and I, as a Anand Margi, is an essential part of Hindu religion. And in that dance on the streets, I have to carry a Trishul and a Damru. So the police commissioner said, what the hell, this is not a part of Hinduism. Get lost, you can't do it. And you can't carry Trishuls and swords and all this on the road of Calcutta. He prohibited it. They went to the writ. The writ was dismissed and Supreme Court upheld the dismissal on the ground that you can protect your essential features, but you can't say that carrying and dancing with a Damru on the street with a sword and a Trishul is an essential part of Hinduism. Therefore, it is protected by 25. Now, this case, Santhara, is a practice which Jains do. It's an affirmative anti-suicide practice which is commonly mistaken as suicide. Those who don't understand the philosophy and the ethos of Jainism. And you will find a lot of old statues and scriptures telling you how, as you age, the idea is to gracefully pass and pass on. So as you age, you are not supposed to do suicide, you are not supposed to do it when you have good health, but as you age, you slowly start leaving each week one item. Today I leave cereal, tomorrow I leave fruit, day after I leave this, that. and I gracefully pass on and die. The Rajasthan High Court, by a very bad judgment, by a judge who didn't understand a word of Jainism or of Santhara or of Salekhna, which is the counterpart. Shwetambars call it Santhara, Digambars call it Salekhna. Said this is all suicide. Suicide is a crime. I ban it, and he passed strictures and he said police should take action. So the old ladies, the old men who want to pass away peacefully, and they are very affirmative. It's a whole family collects around you. The family is affirmative, they say prayers, they support you. It's a kind of a self-penance. If you see the old rocks of Karnataka, Karnataka had a very major Jain concentration. You will still find prince and princesses, kings, taking the vow of Santhara. The statues there. Ignoring all this, the Rajasthan High Court held this. I got to stay here. Again, a very interesting set of written submissions on 25, Article 25. How Santhara, unlike that Tandam Nritya, is an essential tenet of Jainism and hence is protected under 25. On the commercial side, the fifth case was the Cyrus Mistry case. So I am giving you human rights, liberty, religion, and now commercial. And that is why I wrote an article on Ratan Tata's death. I said, I regret the fact that I came to know him very well in his later years. I didn't know him very well earlier. So, Cyrus Mistry, you all know the case. It was very troublesome for the Tatas and for Ratan personally because he was handpicked choice. Anyway, the legal part of it started at the NCLT Mumbai. It was a very prestigious case and I was asked to appear there and lead a team of 5 senior counsel. Very valued colleagues of mine were appearing with me, including, unfortunately, the now unwell Mohan Parasaran and many more. Opposing me were equally 5 senior counsel. It was argued at length, it was a very emotive issue. The issue was the right in the October 2016 board meeting to remove the chairman. Now, as you know, a board can remove a majority unless some is prohibition in the articles, etc. I mean, you may be God, but if all of us on the table decide that he is bad, then he has to go out. He can't stay on. So they removed him. He went to court. I prevented a stay being given. And he went to court without being able to prove that he has even 10%, which is the threshold requirement for maintaining a 241. Those days I think it was AS 241 had come, 397 had gone, which is the oppression and mismanagement. Because strangely the Mistries have a very large percentage of shares, but they are preference shares. They are not equity shares. 10% required is equity holding to enter the 397 or 241 threshold. So we got it dismissed both on interim merits and on maintainability. Very, very high profile, very combative, very jhagde wala case, if I may use the word. Travelled to NCLAT. The NCLAT said this judgment is right, but we will invoke the waiver provision. In the new 241, unlike the old 397, there is a waiver. In the old days, when we started practice, you had to have 10% equity. If you didn't, tough luck. If you had 9.9, you could not file. If you had 9.99, you could not file. Now they say that you have to have 10, but if you are less than 10, for stated grounds in the discretion of the judge, he can waive it. So the NCLAT held against us on waiver. And then, in a very astonishing judgment after 2 years, reversed the NCLAT. Matter came to Supreme Court. Harish and I argued it here. It's only one of the 3 judgments delivered by my Lord Justice Bobde as Chief Justice. So it was reversed again. An entire end was put. Otherwise, it was a very chaotic scene because I pointed out to the court, I said, good or bad, corporate democracy means that you must have trust and faith in those who run the company. I may not like him for the wrong reasons. I may not like her for the wrong reasons. But how can you foist him and her on me, which is unwilling board? How will the company run? So the impugned judgment of the NCLAT in fact reinstated Cyrus Mistry. Of course, Mistry made a statement, I don't want to come back, but I want a vindication. So then it was important to reverse it. Again, a very high profile case. Ratan Tata was beyond his late 80s, mid 80s, he was beyond mid 80s. Whenever I would meet him, he would have a tremor to a very, very perfect gentleman, spoke less. But his whole thing was the legacy I have created, how will it continue after my death? Fortunately, we won that case in the Supreme Court. And that is an important judgment on corporate democracy, on the old LIC escorts majority principle, on chairman being subject to board directives, and so many other issues, written by Justice Ramasubramanian. Of course, unfortunately, it had a postscript, an unpleasant postscript. A review was filed. A review wrongly notice was issued. And a 3-judge bench sat for that. Luckily and unfortunately, 2 judges were inclined to allow the review. But Justice Ramasubramanian openly in the court put his foot down. He said, what is the error? And fortunately, the matter died a death. It was a new bench of the then Chief Justice and Ramasubramanian and a 3rd judge. Anyway, these are the dialectics of Supreme Court. Well, I can go on and on. I have defections as another head under Article 356. Defections, 356, and the whole related gamut of issues which are political in nature. I've had the privilege, friends, and perhaps the misfortune of appearing in every major defection or 356 case. Maharashtra or the midnight hearing cases, Karnataka. So basically they are all related. Defection, change of government, floor test, and of course overriding 356. So Uttarakhand was more 356. The midnight hearing we did here in the Supreme Court was more toppling by having a floor test delayed. So I contrive a majority, delay a floor test and then do. So these have included Jharkhand, Chhattisgarh, Uttarakhand, Maharashtra, Karnataka twice, and many other, Arunachal Pradesh. And all of these have shown, I have not got time to go into the details, all of these have shown the nasty, brutish and short underbelly, both of the theoretical structure and system we have created. The Indian genius to destroy the system has succeeded, and the system and the structure we created has failed. Today, 10th schedule is a mockery. You should just have a 2-line 10th schedule. Anybody who changes the party from which he was elected will have to seek re-election. We have spent, 10th schedule came in 1985 by Rajiv Gandhi. Ashok Sen was the law minister. From 85 till now there is 40 years. The biggest mockery of 10th schedule has been made in 40 years. So these are cases where 10th schedule, if I am in power, my speaker will delay deciding if the decision will go against my party. If I am the opposition, then the speaker will decide the same disqualification petition very quickly, so that the people are disqualified. It's happening every day, and it doesn't matter whether you are political party X or I am Y. Then this floor test, I will first buy all of you MLAs, then I need about 5 more, so I will delay the floor test with a friendly governor or a friendly central government. Then when I have got my gang together, then I immediately have a floor test. So the courts have said have the floor test right now. That's what happened in Karnataka in the midnight 2 hearings. So when the floor test is held immediately, then you can't have a contrived majority, because you are making a contrived majority by defections. Uttarakhand, that you first create a destabilization, you make a government fall or about to fall, then you try and collect MLAs, but you can't collect, so you impose 356. That was Uttarakhand. So I give you 3 models, different models. All these have been interesting cases in my life, and they do form part of some memoir I have dictated. So maybe, but these are already in a book. Then of course, I don't have time for it, a same-sex case, a major case. Very, very innovative, very detailed constitution bench, and we enjoyed it. And against all expectation, the government succeeded. But advances were made, a lot of rights were created. In the same-sex case, I cited a UK House of Lords judgment, where there is no constitution in the formal sense, where judicial review is much more limited, and where interpretive acrobatics are much more limited. In that, they had held two males to be husband-wife by interpreting a rent act provision. When two people living together, even though it says husband and wife in the act, will include same-sex couples. But our court heard at length, went thus far, but came back. So I told them, I said that principle is nothing, the principle of the House of Lords is nothing compared to the power of judicial review you exercise. But I think there was a fear of a social backlash, and they hesitated and drew back, because earlier they were going very far. So anyway, this is a summary of what I wanted to say. I want to end by saying that there are many, many more cases. This is like 5-7 years old. You sometimes learn a lot about how law develops, how the story behind the story gives you a true picture of the dialectics of law, the context in which it arises. Law plays very little part, the context plays a major part also. And how sometimes quirks of fate develop a legal principle, like the right to fly the flag case, or like the other case, the Yellow Pages case, etc. etc. So it's always a learning process for me, and I hope it's a learning process for you. Thank you very much.
Thank you very much, sir. We are highly grateful to you. The way you explained all your judgments is 100% learning for all our generation lawyers. It's a stimulating and learning process, lot of learning. The way you came out of the way and you given lectures. And since yesterday morning onwards, I'm hearing from so many people all these judgment which you argued, they're appreciating like anything. You can see how much crowd never happened in this library, Lord. Sir, amen. Rahul Agarwal will give you a vote of thanks. And second, sweets are available. Kindly wait and collect. And let us give a standing ovation to Singhvi Sabhi. Rahul Agarwal will give a vote of thanks.
Good afternoon, everyone. It's my honor and privilege to deliver the vote of thanks on this truly special occasion on completion of 275th Friday Group meeting. And for today's session on important cases argued by Dr. Singhvi has been both enlightening and deeply enriching. At the outset, we express our profound gratitude to our distinguished speaker, Dr. Manu Abhishek Singhvi, Senior Advocate, for his insightful and thought-provoking addresses. Your explanation of your landmark judgments, your nuanced understanding of law, and the clarity with which you presented complex legal principles have all greatly enriched our knowledge. We are sincerely thankful for the time, effort, and intellectual depth you brought to this session. Today is a very auspicious day as the Friday Group celebrates its 175th meeting, a 275th meeting, a remarkable milestone in its inspiring journey. Over the years, the Friday Group has grown into an institution in itself, dedicated to fostering learning, discussions, and legal awareness. It has played a significant role in helping advocates and law students expand their knowledge, refine their understanding, and stay connected with the evolving landscape of law. This achievement stands as a tribute to the collective passion for learning that binds us all. All this is possible only because of the strength and backbone of the Friday Group, one and only G.Seshagiri sir, as we call Sheshu sir, the respected administrator and the organizer of the Friday. His unwavering commitment, tireless efforts, and visionary leadership have been instrumental in making this platform which is today. We are deeply grateful for his dedication and for consistently curating such impactful and meaningful sessions. My heartfelt thanks also go to our esteemed members and senior advocates for gracing the occasion. Once again, we extend our deepest gratitude to Dr. Manu Abhishek Singhvi sir for his illuminating session and to everyone present for making this truly remarkable. Thanks you all. Have a wonderful day.